This is Mike Stalker from Labaton Sucharow. We're pleased to welcome our online audience to our webinar on Securities class action trials in the wake of the financial crisis. In addition to the PowerPoint presentation that you can find on the WebEx site, we have also provided you with some illustrative materials, including some sample verdict forms and jury questionnaires from securities cases that have recently gone to trial. We will be referring to these documents from time to time in today's presentation. I'd also like to welcome our distinguished panel. James Bennett of Morrison Forster has first chaired more than 30 complex jury trials, appearing for both plaintiffs and defendants. In 2008, Jim was recognized by California Lawyer magazine as an Attorney of the Year for his successful defense of JDSU Corporation and its former executives in one of the largest securities fraud class actions to proceed to trial. Appearing opposite him in the JDSU trial was our own Mark Arison. Mark has long experience with litigation under the federal securities laws. In addition to leading the plaintiff's case in JDSU, Mark briefed the landmark insider trading case of Sucharow versus United States before the United States Supreme Court. More recently, Mark was recognized by American Lawyer as Litigator of the Week for his success as lead lawyer for the plaintiffs in the trial of a federal securities fraud class action against Bank Atlantic, the first securities fraud class action case stemming from the financial crisis to go to trial. Our panel discussion today will focus on some of the substantive and logistical challenges facing attorneys preparing for trial, not just in securities fraud class actions, but in complex litigation in general, and also on some of the challenges that are peculiar to cases stemming from the financial crisis. After the panel discussion, if time permits, we will have a question and answer period. You can submit your questions directly through the chat window. Only you and the panel will see your question. I'd like to start with a general question. Mark, the title of our program refers to securities class action trials relating to the financial crisis. I know you've just been through the Bank Atlantic trial. Is there anything about financial crisis cases that makes them especially challenging to try before a jury?
And the answer to that is yes. Jurors are sometimes going to be afraid of dealing with complex financial matters. Initially, they're going to think that they don't have the capacity or the ability to understand complex financial matters. And they wouldn't be wrong, because in these kinds of cases where you're dealing sometimes with derivatives, financial derivatives, and credit default swaps and things like mortgage-backed securities, even highly educated financial people and sophisticated lawyers have a great deal of difficulty in understanding what the nature of those kinds of investments is. So it is a challenge, I think, to the plaintiff's lawyer to make those kinds of investments in the financial crisis case simple for a jury to understand. And whether you use experts to do that or you use clever demonstratives to do that, the key is to make the investment vehicle that's at issue in your case understandable and simple.
Mark, why is it, given those challenges, that a plaintiff might want to try a complex case to a jury rather than to a judge who might more easily be able to understand some of the complicated legal and factual issues present in these kinds of cases?
I think the essential reason is that a judge is less likely to be impressed with evidence of fraud that will outrage most jurors. You will have jurors sitting in a case that you can appeal to their human nature, have them want to hold people accountable for having done things which were improper or fraudulent. And there's nothing wrong with a plaintiff's lawyer appealing to a juror's human nature to say to a defendant, we are going to hold you responsible. Putting your faith in the hands of a judge, even a very good judge, you're basically going with the vote of one person, whereas for a jury, you are looking at the common wisdom of the community.
And Jim, given the potential benefits to plaintiffs in trying their case before a jury, how often, in your experience, have you seen plaintiffs waive the right to jury trial?
Well, it's definitely the exception to the rule. but it's seen. I've seen plaintiffs waive juries in cases involving commercial subject matters, in cases involving financial institutions. Why have I seen that happen? For a variety of reasons, which you can intuit or infer, which include the plaintiff counsel might think that their own client might be more sympathetic to a judge than to a jury. B, but more typically, I think it's that the plaintiff will have assessed a particular judge in a particular jurisdiction as being at least as good for them and maybe better than a jury. And very simply, it comes down to making a decision about the judge in question. It may be based upon their knowledge of the judge's particular view on a type of case. It might even involve experience rulings a judge has issued in related or similar cases. But those are typically the circumstances that would drive a plaintiff's lawyer to prefer a judge to a jury.
And Jim, with the understanding that defendants most often have little choice in this matter, I'm going to ask you to speculate a little. And if defendants could choose whether to present their arguments to a judge or to a jury, which would they go with? And let's leave aside for a moment the issue of quirks in a judge's personality or perhaps some kind of bias from the bench.
Well, I think the things that typically would motivate you to prefer let me start with why do defense lawyers typically prefer a judge? Oftentimes, the defense is based upon rather technical legal points or a fine appreciation of the case law, which obviously only a judge in a bench trial will apply. So why with all those benefits would a defendant want a jury? In my experience, it would typically come down to, and I don't want to put this as quirks, but having a sense that for your case, for your client in this subject matter, you can almost predict the judge is going to be against you. That's why you would want a jury.
But on the other hand, if I could just add, a jury in this day and age is likely to think ill of a white-collar corporate executive accused of fraud. So the plaintiff goes into the case with a built-in bias generally in his favor.
Yeah.
Now, let's turn to I think a closely related issue, and that's of jury selection in these complex cases. And this is a question now for both of you. First, in your experience, how common is it for federal courts to permit lawyer voir dire in jury trials?
Well, I'll take that. I think it is extremely rare. In fact, I've never seen a federal court judge permit a lawyer to do even a limited voir dire, although I have heard that it has happened. And the essential reason is time. The judge who is actually trying a case has got a big motive to get the case tried efficiently and expeditiously. And sometimes lawyer voir dires in the states, for example, like New York, where lawyer voir dire is permitted, a voir dire by a lawyer could take a whole day or longer. Whereas in the federal court, jury selection sometimes takes 90 minutes or 2 hours. So it's efficiency and time. The other reason is that when the judge conducts the voir dire, it's much more controlled, and you don't risk the possibility of a wild question coming from a lawyer that will result in an answer from a juror in front of an entire panel that could poison the entire panel with some craziness coming out of the potential juror's mouth, and you'd have to start all over again.
Jim, is that your experience as well?
It's the universal experience that in federal courts, lawyer voir dire is a dying practice. Having said that, and having in mind the subject here today, the financial crisis, because of the high public opinion profile here, you're talking about a institutional crisis that has prompted recipients of Academy Awards to comment on it within the last couple of weeks. Judges you should ask, if you think voir dire is important, and it is, to identifying juror bias, you should ask the court for an opportunity to conduct voir dire. A fair number of federal courts will allow individual voir dire in chambers, or even voir dire of the entire panel on a one-by-one basis in chambers to prevent contamination of the entire panel, and that's a process that I recently participated in Delaware, and it went very quickly. Within 90 minutes, we had a jury selected, even with individual voir dire in chambers. So I think the defense lawyer's job is to persuade the court that voir dire can be accomplished without prolonging the selection process and without tainting the jury, and there are examples that can be given to the courts. Of course, the first thing from the defense point of view, you want to know the practices of your judge regarding voir dire, so you'll walk in there armed to deal with it and persuade, if necessary, the judge.
And Jim, given that lawyer voir dire seems so restricted in general, have you found that courts are more tolerant of the use of jury questionnaires, say, to explore jurors' backgrounds?
Yes, again, and again, you should know your judge's practice, but I would say, in my experience, roughly 50% of the judges will allow questionnaires, especially in a long and complex case. You should research your judge, know what history they have giving questionnaires, try to tailor any questionnaire you propose to the court so that it looks and feels like something that they have allowed in the past. Any questionnaire will have to be mutually agreed upon with your opponent, so it should have been the subject of negotiation, and when you raise the subject with the court, parties should be prepared to jointly propose a questionnaire that essentially they've agreed upon. Having that in mind, you should recognize that the questionnaire process is going to be give and take. It's going to be equal in the sense that the plaintiff's counsel, if you're the defendant, is going to have their questions in there, and you'll have to negotiate all that. But I would say in a case that was at the epicenter of the financial crisis, I would think you have a very good chance of getting a questionnaire with most federal judges.
Coincidentally, today marks the first day of jury selection in the insider trading case against Rajanatram. On the Wall Street Journal's online site, in fact, you can find a jury questionnaire approved by the court that will be used in that case. In the case, the court asks jurors, among other things, I guess it's prospective jurors, among other things, whether they would be able to render a decision without being influenced by feelings about the financial crisis. Now, this is a question for both Mark and Jim. If you were representing parties in a case related to the financial crisis, what kinds of questions do you think would be useful to ask?
Well, from my perspective as the plaintiff, there are two general things I would like to find out. First of all, I think the use of questionnaires, if permitted, is an extremely valuable tool to allow lawyers to select a jury that is rid of people who express some kind of a bias that would prevent them from being fair and impartial. But generally what happens in cases is that people will express a bias, and then the judge, in an effort to eliminate a for-cause challenge, will question a potential juror to eliminate from the juror saying that he can't be fair. So if somebody comes in and says, I can't be fair in this case, Judge, the judge will say, well, what if I asked you, can you decide this case based upon everything that you're going to hear from the witness stand and everything you're going to see in the exhibits that are entered into evidence? And can you decide this case strictly on the basis of the law as I instruct you and put aside any personal feelings that you might have? Virtually 100% of people who are going to be asked those questions are going to agree. And what you end up with is a juror who has expressed the possibility of bias, so that you certainly, as a lawyer, can exercise a peremptory challenge against that juror if it's extreme. Of course, the strategy that lawyers like to use is to push and ask the judge to follow up so that you have a possibility of getting a biased juror stricken for cause, so you preserve your peremptory challenges.
Jim?
Well, the question is, what type of information would I be looking for with which to intelligently exercise a peremptory challenge? And in a case involving the financial crisis, in questionnaires and so forth, you would have been provided with perhaps opinions people have about that, and I think it's predictable that most people who would venture an opinion about the financial crisis would venture opinions that would not be favorable to the defense side of it. Notwithstanding that, most of them would probably survive challenges for cause. So how do you go about exercising your precious challenges? One of the bits of jury selection wisdom that I found most true over the years is that while a juror's opinions about certain subject matters are important to know, their life experiences are even more important than that in terms of the decisions they will ultimately make as jurors and the influence they will have within the jury when it actually is deliberating. So in addition to eliciting opinions about, jurors' opinions about such things as a financial crisis, it would be very important to know what experience they have with financial institutions. If you have a juror that's had a bad experience with a financial institution, that's somebody you do not want on that jury, and you need to identify that. Similarly, experiences they have had as investors, if they have had bad experiences as investors and they blame someone other than themselves for their losses, that's a juror who should be high on your list of candidates to strike, probably higher than a typical juror who just expresses the conventional negative view about the financial crisis and its causes, which, of course, over the course of a trial, your whole task would be to educate the juror. Well, that may be that general problem out there, but this case doesn't involve that. That case involves this defendant, these individuals who were not part of that, who just did their job, and the plaintiffs are frankly trying to unfairly taint with that general stuff.
Of course, all of these generalities might or might not apply in a particular case. I think one of the things that I go with in selecting a jury is to try to identify leaders and followers. And if you have a follower who is negative towards your position, that's not as bad as having a leader who is negative towards your position. And obviously the other side would be in the same way. So, for example, if you have a juror who answers a question about plaintiffs and class actions and plaintiffs' lawyers and thinks that all people who invest in the stock market are gamblers and deserve their losses, if that person is a leader, that's certainly somebody you would like to get off the jury. On the other hand, if that person is a follower, but you have other strong people who are leaders that have negative positions, you want to exercise your challenges to get rid of strong leadership type people who have positions that are against your client.
Just absolutely agree with that. And one thing I would add is that I think, and it's the jury consultants who actually study this over broad numbers of jury pools and individual jurors, but it's all of the things being equal, the jurors who have experiences close to the subject matter of your case are more likely to assume a leadership role in the deliberations because, if nothing else, their emotional investment.
Now, these complex cases, when they go to trial, the trials can last for weeks or months. And how is it, this is a question for both of you, that the demands of being able to sit for weeks or months on end shapes the demographics of the jurors who actually get seated, and how does that affect, do you think, your chances of success as a plaintiff or defendant in these cases?
Well, as a plaintiff, I think that that dynamic is in favor of the plaintiff's side. I think as a plaintiff, you do not, in these kinds of cases, you would prefer not to have on the jury corporate executives, for example, who prefer not to sit on juries, business people who prefer not to sit on juries, highly educated people who are sophisticated in the financial world, you would prefer not to have on juries. So I think that by elimination of those types of people on the jury panels, you're likely to have people more willing and more able to serve on lengthy trials. And I think that dynamic favors the plaintiff in terms of who you're likely to end up with.
And Jim, would you say that you agree with Mark's assessment that that dynamic tends to favor plaintiffs rather than defendants?
I agree that that's the conventional wisdom. There's no question if you brought in 20 jury consultants who, as I said, have more experience than the lawyers in terms of actually picking and seeing large numbers of juries, they would all say that on balance, the longer length of trial would favor the plaintiffs. Why is that? Long cause juries, you'll have people, anything over 3 or 4 weeks would typically be a long cause jury. Jurors get off for hardship, such that what you're typically, and again, this depends a lot upon the judge's practice, your trial judge, how tough he or she is on excusing people for hardship. But the likelihood is you will end up with a jury composed of government workers, municipalities and state workers whose employers will pay for jury service over an extended period of time. You'll have retirees, and you will have employees of companies that will pay for jury service for 3 or 4 weeks or longer. You won't have executives. I've very seldom seen executives come in even for short cause cases, but you won't have executives. You won't have entrepreneurs. You won't have people who own their own businesses and so forth. So for all those reasons, the conventional wisdom is you end up with a jury that demographically is a more plaintiff-friendly jury. Having said that, over the past 4 years, I've probably tried 5 or 6 long cause cases and have ended up with juries that, with jurors and juries that were much better than you would expect, and had 4 persons in 2 of those juries, a retired foreperson in one case and a government worker in another, who were quite analytical, quite sophisticated. The retired juror was had a double MD in psychiatry and radiology. So there are no hard and fast rules, is what I would say here. And the fact that you're a defendant facing a 4 or 5 or week or long cause trial should not in itself be a source of despair.
One little footnote on that, Mike, is that what you don't want to do in a long trial as a trial lawyer is have the jury believe that you're extending the length of the trial, either by making long-winded or bad arguments, or examining witnesses longer than necessary, or getting into arguments with the court or the opposing counsel. If the jury starts thinking that they're sitting there for weeks on end because of your conduct, that could end up losing the case for you.
Now, I'd like to wade into a hotly debated point about the use of jury consultants and mock trials in preparing for trial. Mark, would you use a jury consultant, say, in helping you craft a jury questionnaire, or perhaps in better understanding a jury once it is seated?
Yes, and I've done that, and I think jury consultants are extremely useful in using their background and their experiences in helping you craft the questionnaire to ferret out the kinds of biases that you might not otherwise get from a judge of voir dire. So I think it is very useful to have a jury consultant help you in fashion a questionnaire, with the goal being that, as Jim said before, you want agreement with both sides to be submitting a proposed questionnaire to the court so that the questionnaire would be used. I think both sides generally would agree that the use of questionnaires is extremely helpful, and it is a good thing for both sides to be persuading the court to allow it to happen. And so what you want to do is have a questionnaire that is neutral, that ferrets out bias on both sides, and that doesn't spend a lot of time, or any time really, in lobbying for one side's position or another. And jury consultants can help you do that very effectively.
And Jim, your view on jury consultants?
With respect to questionnaires?
Yes.
Pretty much the same as Mark's. I would say that the jury consultants should be, if you have the right jury consultant, he or she should be a resource in terms of preparing a questionnaire, and that they will inevitably have exemplars from similar cases. More often than not, exemplars that were used have been used in trials presided over by your judge. And as Mark says, getting beyond the exemplars and customizing a questionnaire to your case, the consultants will have useful insights into the types of questions to ask and not ask. As both of us have said, you're going to end up with a balanced questionnaire that gets at both sides' concerns about possible or potential bias in the jury pool. But one thing your questionnaire can help you do is not in your questions, and the questions you put in this questionnaire, what you're trying to do is identify bias that would cut against you. And it may be that there are questions that you don't want to ask and that they will simply identify bias that cuts against your opponent and will help inform your opponent's use of their precious stock of peremptory challenges.
And Jim, I suppose it's a little more controversial whether jury consultants continue to be useful once a jury is seated and they're observing the behavior and the demeanor of the jurors and trying to offer advice on what it means for your case. Do you use jury consultants in that capacity?
I've never done it in a formal sense. I have a consultant I work with regularly, and I have occasionally he will sit in and observe a key witness and a jury's reaction to that. But I have, in only one case have I gone to the formal effort of having a shadow jury, for instance, which I did in one case, and I frankly terminated the exercise after the first 3 days. I thought it was too much information, and it was potentially confounding information, in that the composition of the shadow jury did not match the composition of the people in the box. And at some point, I believe you've got to let yourself loose of the consultants and go on your own experience, your ability to not just present your case, but read the reactions of the jurors who you have decided are the best you can live with in that box.
Mark, you look like you agree.
I totally agree with Jim on the shadow jury. I think it is an absolute waste of time and waste of money, and very diverting. You end up, the end of a court day, you have overnight to prepare for the next day, and the last thing you want to do is hear some jury guru talk about, you know, the impact that that person believes the witness of that day had on the existing jury based upon another jury's view. So I would never use it.
And what about mock trials, Jim? Do you find mock trials useful in testing your case before the real thing?
Absolutely. I'm a strong believer and endorser of mock trials, and with respect to our topic here today, if you had a case that involved the quote-unquote financial industry crisis, I think you definitely want to do a mock exercise to see how just the general perceptions about that subject matter might affect or impact your case. Now, having said that, generally with respect to mock trials, they're not predictive, but they have real value in my opinion. From a defense point of view, they will give you an indicator of whether you have a triable case. They can't predict that you're going to win, but I think that you do get an idea whether you have a triable case. I think that the preparation that goes into preparing and conducting a mock trial exercise, where you or one of your colleagues will play your opponent, play the plaintiff if you're the defendant, is invaluable. I think the exercise requires a disciplined anticipation of the plaintiff's case. One of the great benefits is you will have thought the plaintiff's case through in a way, and their trial presentation in particularly through in a way that you won't, in my experience, if you don't do that exercise, and it greatly reduces the surprises you experience at trial. While not predictive, I think of the ultimate outcome, I think mock trials are accurate indicators of your strongest and weakest points, and with respect to the latter, really help you anticipate, address, cabin, if you will, those points so that they don't overcome your case. I think they're very valuable in identifying gaps in juror comprehension. By that I mean, while all the lawyers who've worked on a case for 2 years may understand what a 10K is or what gap is, You have to realize, and mock trials are invaluable, I think, in helping you realize that there'll be just points that you need to teach and explain to a jury. Otherwise, they won't grasp your point. So my bottom line is that it is well worth the effort. They're expensive, but I think from the defense side, they're worth the effort.
And Mark, your view?
I'm not so sure that I agree with Jim on this one. I think that there are definitely benefits that can come out of a mock trial exercise, but from the plaintiff's point of view, there are some significant differences. The first is that unlike a defendant who generally is going to have lots of money to throw at a defense, sometimes for a plaintiff cost is an issue, so that if you are dealing with a mock trial exercise that could cost, say, $100,000 for a one-day exercise or $200,000 for a two-day exercise, sometimes that's a consideration. So cost is a consideration. Do you get enough information out of it to justify that kind of an expense is a real issue. The second thing is that when you present a mock trial to a mock jury, theoretically, the jury that is selected to listen to your presentation is supposed to be the same cross-section of the community that you would get in the actual selection of the jury. So even assuming that's the case, you're going to be presenting to that mock jury panel a case that is severely truncated. You're going to be presenting a case from start to finish in what we call a clopening, which is a combination of a opening and a closing statement. You're not going to have, generally speaking, you're not going to have live witnesses testifying. You're not going to have real cross-examination. You're not going to have day after day after day of this mock jury being really involved in the ins and outs and day in and day out struggles of a real trial, so that by the end of a 3-month trial or a 2-month trial, certainly most jurors are going to understand what a 10K is. But, in a one-day exercise, you're going to get just the tip of the iceberg of what your case is about. You may not even be able to present all of the issues. You may not be able to present all of the defendants. So you are possibly going to get a false read from that truncated version. In addition, I have found that as hard as you try to duplicate the presentation of your opposing counsel, you're never going to be able to get a role player to get up to speed and deliver the kinds of arguments with the passion and enthusiasm as a real opposing counsel is going to do in the courtroom. So you're going to lose that as much as you will try to duplicate it. It really is not going to be effective. So while I think that you do get valuable information from mock trials, especially in the area of whether a group of people is willing to accept your broad arguments, whether a group of people is willing to award damages, for example, I would not put a lot of stock or faith in the predictability of a mock jury.
Jim, any response to Mark's suggestion of the deficiencies in mock trials?
Well, I think we agree more than we disagree. I think Mark is right, and he's pretty. And one reason you recognize going into a mock trial is not predictive is that it does not in any way duplicate the evidentiary portion of the trial. So you really can't test the credibility of a witness. You can't anticipate a witness doing poorly on cross-exam unless it's on a videotape deposition and you can show it to a mock jury. But that is not the purpose of the mock. The purpose is, as Mark alluded at the end, to see how a jury at the beginning, that is after opening statements, and at the end of the day in closing, is going to react to some basic points, arguments, themes, storylines, call you what they will, that you can forecast are going to be the subject of discussion, argument, debate among jurors in their deliberations. And in my experience, it's invaluable. We never get to see a real jury deliberate, so we don't know what goes on in there before they return their verdict. But in the whole point of the mock trial exercise is to watch 1 or 2 or 3 mock juries deliberate and argue points. And I think you do get very telling insights into what the ultimate arguments in a jury room are likely to sound like. around certain key points in your case. And while not predictive, it helps you, I think, refine and shape and maximize the effectiveness of your trial presentation.
And Mark and Jim, given your, I think, agreement that the scope of the evidence that it is possible to present in a mock trial is much smaller than what you can get in a real trial, how useful do you think mock trials are for engineering settlements?
Well, again, I think that probably is the most useful part of what you get out of a mock jury. I think you get a good read on whether a jury is willing to award large damages. I think you get a good read on whether you have a case at all or whether you have a defense. And if you do a couple of mock trials and it consistently comes back that you lose, I think that you're more likely to lower your settlement expectations if you're a plaintiff, or raise your settlement expectations if you're a defendant. And I think that is probably, from my perspective, the most useful takeaway from a mock trial exercise.
Jim, do you agree? And if you do, how early in a case would you suggest having a mock jury?
I do agree that, I don't know if it's the principle, but a principal benefit of mock trials is deciding, is in helping you to assign a settlement value to a case from a defense point of view. As I said, I think the first thing you're testing when you do a mock exercise from the defendant's point of view is whether you have a triable case, if there is any question about that. And I think in cases that involve corporate clients, that involve very large exposures, I think it's very important to advise your client, to fulfill your job as a lawyer, to have an empirical basis upon which to advise a client. This case is defensible. The facts here are defensible. The facts matter in these cases. These facts are defensible. These witnesses can present these facts in a manner that a jury will identify with. And I think the ability to advise a client that we have tested this and it is a defensible case has, in many instances in which I've been on the defense side, that has been a key factor in the defendant's willingness to see the case through to trial. And in terms of the timing of a mock trial, I would say the earliest I've ever done one is roughly a year before trial. I think, picking up on one of Mark's points, it is important for the mock to have value, to be able to faithfully and effectively replicate your opponent's presentation. And frankly, the case will have to have been pending for some time, and you will have had to have sat through some depositions and seen their arguments unfold, and have the benefit of knowing through discovery what the key evidence is that your opponents are going to rely upon, present that in a mock to get a good read. So I would say the earliest I've ever done it is a year before trial. Typically, you try to do them 6 months before trial, though, so that the actual conducting of the mock doesn't interfere with, or vice versa, with the immediate trial preparation and filings that are required in federal court and so forth.
Now we're going to get a little into the nuts and bolts of presenting these complex cases for trial. Mark and Jim, why is the drafting of jury instructions and verdict forms such a challenge in complex securities fraud class action? Mark?
Well, first of all, the law in this area is extremely complex. The kinds of things and the nuances that a jury has to be instructed about are many. And for securities fraud, there are 5 separate elements that a plaintiff is going to have to prove. So aside from the usual boilerplate stuff that a jury gets instructed about, for example, burden of proof and credibility of witnesses and the general things that jurors are told, they have to be told about the fine points of securities laws. And that is not easy. And so you would have lawyers who spend hundreds and hundreds of hours drafting jury instructions and negotiating jury instructions and having charging conferences with the court about the fine points of jury instructions for days on end before the jury is actually instructed, and then the jury instructions boil down to, an hour of the judge reading in fairly rapid time a set of instructions that for many of the jurors it's going to sound like a lot of gobbledygook. And to some extent that's ameliorated by the fact that some judges allow jurors to take the instructions into the jury room. But, you're going to have in the deliberations with complex verdict forms to fill out. I don't know how many of the jurors are going to sit there and start studying the complexities of the instructions. So I think the key in the drafting process is to try to get these complicated concepts into understandable and simple language. A lot of the judges strive to do that. Some, basically use the boilerplate standard instructions that you find in the instruction books without trying to make them understandable in the particular case that the jury is sitting in. So I think if you're lucky, you'll get a judge who will try to help you help the jury understand what the law is. And that's obviously what you want. You want a jury to understand what the law is so that they, if you're a defendant or a plaintiff, so that you have a case that's based upon the law or a defense that's based upon the law. You hope, in the end of the day, the jury is going to understand enough about the law to apply the law to the facts. So we'll talk about the jury verdict forms separately, I guess.
Jim, any general thoughts about jury instructions?
Well, yeah, I would. One of the things I wanted to say at the outset of this presentation was while we're talking about trials involving financial subject matters, including securities cases, when we were preparing for this, Mark and I were talking about how this is more about how trials are more like trials in any other commercial setting than unlike, and there are many common features here between trying a securities case and just trying a general commercial case. One of which is this, that the jury instructions that the parties end up with are going to be fashioned by the court to be as neutral as possible. They'll cover the range of subject matters, but they'll be neutral instructions. That is, they won't be loaded up with one side's favorite quote from a case on C-Enter or the other side's favorite quote from a case on C-Enter. It'll be a fairly neutral instruction. A lot of the time that is spent by the parties preparing, submitting, and arguing about jury instructions, a lot of that is each side drafting up its wish list of instructions, which very seldom actually get rendered. What's rendered by the court is a relatively neutral expression of the law at the end of the day. There are a number of subject matters that are covered here, though. I pulled out the JDSU instructions, and in that case, our court, over roughly 7 or 8 pages, instructed the jury on just the basic elements of Section 10B, then instructed separately on what constitutes a misstatement or omission, instructed separately on forward-looking statements, instructed a short paragraph on what opinions were actionable under 10B, instructed on materiality, instructed on cautionary statements, instructed on C-Enter, instructed on loss causation, among other things. I'm leaving out some things. And then instructed on Section 20, control person liability. And I'm counting it here. I'm sure that the 8 pages of instructions that were ultimately given there were the product of probably hundreds of pages of competing instructions from both sides and many hours of argument to the court beforehand. But what you end up with is something, as I say, that's fairly vanilla, for lack of a better word. And as in any case, you asked about timing of a mock trial. Well, one thing you should do early in a case is take a look at it and get some exemplars or think about what are the ultimate jury instructions in this case going to look like, and what are we ultimately trying to prove or disprove in this case, in light of those jury instructions.
And now turning to the opening statement, first, just generally, why is the opening statement especially crucial in trials of complex cases, and what advice would each of you give to practitioners about key things to accomplish in opening? Jim?
Well, from the defense point of view, the opening statement is very important. Any trial lawyer will tell you it's an opening statement. It's not an argument, but a well-crafted and delivered opening statement is in effect an argument in that it is the most persuasive marshaling of the best evidence that you have to support your case, and should be presented very forcefully. Some sort of stock things that I think any good opening would include would be an enumeration for the jury, maybe in a simple graphic, a chart with which you start and end your opening of what you say are the key facts on which your defense turns, the pillars of the defense, if you will. In addition to that, all trials are about storytelling, and any plaintiff's presentation or defense, there will be a number of key storylines that both sides will be presenting to the jury. I think you need to present those storylines to the jury in the course of your opening. Probably have timelines that would allow the jury to start appreciating what those key storylines are. There is an educational burden, which both sides have in delivering an opening, but you need to explain to the jury any key accounting, industry, other technical terms which they need a little bit of education on to appreciate your case as it comes in. Its opening statement, it's intended to persuade, but it's also to provide jurors with an intellectual pegboard, if you will, so that as the evidence starts unfolding, oh, I understand Bennett is eliciting that testimony from this witness because it relates to that issue that he referred to in opening statement 2 days ago, and allows them to organize, integrate the evidence as it comes in the way you want them to. Finally, I would say one thing that's very important for the defense to do in opening is if you have a weak point that you can effectively deal with or even concede, do it at the outset. Diffuse what you think is going to be hay, which the other side will make out of a point, which you can generally at the end of the day and persuasively at the end of the day argue is collateral or beside the point. Take it on early, diffuse it, and you should always be considering whether there are points in the case that you can effectively deal with in that way in opening.
Mark, suggestions for practitioners?
The plaintiff in a securities fraud case has an incredible advantage in giving an opening first. The first words that the jury is going to hear about the case is coming from the plaintiff's lawyer. And it is an extremely important tactical advantage that a lot of lawyers don't take advantage of, but it should be taken advantage of. It is the first thing the jury is going to hear about the case, and it's the thing the jury is going to remember as the case goes forward. By the time the plaintiff is finished with his opening statement, his or her opening statement, oftentimes you've either won the case or lost the case. Case over. And by the time the defendant stands up, it's already 2 hours or 3 hours into a presentation. The jury is going to be tired and not as attentive as the jury was listening to a plaintiff's opening. It's very important to keep the story simple. Tell the story in terms that a jury can relate to in their lives. Keep it interesting. Use analogies if that works. It's important to explain the business that the defendant company is in and explain how the business works. And if you're representing a class of investors, explain what it is the investors need to know about the defendant's business before they invest in the company, and then tie that together with what the fraud in the case that you're alleging in the case is. It's good to remind the jury what I called in the Bank Atlantic trial the golden rule that applies to public markets, and that is that public companies have an obligation imposed by law to disclose, to make full disclosures, to tell the truth and the whole truth, whether it's good, bad, or ugly. They can't leave things out. Explain to the jury what an omission is. Some people find it very difficult to understand from the outset what it means to commit a fraud by failing to say something. So use an analogy to explain that in simple terms. I think we did that in the Bank Atlantic case to good use. If you have a couple of key exhibits that you know are going to come into evidence, publish them to the jury if the court is going to allow that practice right up front so that you are on the attack, showing your best pieces of evidence right from the beginning. If credibility of the defendants is going to be an issue, highlight that for the jury up front. Explain to the jury why credibility is going to be an issue. And finally, I would say that as a plaintiff in these kinds of cases, one of the major difficulties is that most all of the plaintiff's evidence is going to be coming from witnesses who are directly or indirectly controlled by the defendant. If you are in a situation like that, I think it's important to explain to the jury up front that in your opening that you have no friendly witness that you're going to call, that every single witness you're going to call to the stand has some hostility towards your position. And what that does is it sets up nicely the fact that you're struggling to get the proof out and you're going to call hostile witnesses, and during your examinations you're going to do your best to get out from them what you can, but it sets up right from the beginning the fact that the defendants are controlling all of the information in the case, and you're going to get out of them what you can from the witness stand.
If I can just comment briefly, Mark is absolutely right. Plaintiff, the ability to go first and go last in the trial is an advantage the plaintiff enjoys that far outweighs the minimal burden placed upon him in a civil case under the preponderance standard. One of the advantages is being able to get up and give an opening statement, but a well-planned and delivered defense opening will have anticipated what the plaintiff is going to say and effectively respond to it in a way that doesn't sound defensive, but the storyline you present, the key facts you present in your opening, will have been carefully crafted to respond to what the plaintiff has just presented. To go back to mock trials, one of the benefits of a mock trial is you really, I've very seldom been surprised by much of anything I've heard in plaintiff's openings in the past 10 years since I've done mock trials regularly. And in a big enough case, we will typically even just mock openings, competing openings, to make sure that the defense opening at the very least has brought the jury back to a state of neutrality, if you will, and a state of open-mindedness and prepared to receive the evidence. If you can't do that in a defense opening, you should question whether you have a triable case.
Before we leave the presentation of cases at trial, Mark, do you have any general suggestions about verdict forms?
Well, here again, it's a question of the complexity of this area of the law. If you have a plaintiff's case that involves numerous false statements, you're going to have a jury weigh in on whether a series of false statements was proven to be true or false. If you have multiple defendants, you're going to have a jury having to decide liability of multiple defendants. There are issues of comparative liability in these kinds of cases, and of course there are complex issues about damages and loss causation. So inevitably you have built-in complexities that will require the verdict forms in these cases to be extraordinarily lengthy. We have in the material some quotes from the judge in the Bank Atlantic case. The first quote is from the judge to the lawyers, and the second is what she actually told the jurors. But what the judge did there, which I thought was fairly remarkable, was after giving the instructions to the jury, she came down off the bench and put the verdict form on an Elmo and went through the verdict form page by page with the jurors to show them that it was something that, although complicated and long, something that they could work through. And I think for a plaintiff's lawyer, that's extremely important. You don't want to have the jury throw their hands up and say, what's the quickest route to go home? Say no to the first question and you're out of here. You want the jury to feel empowered that they have the ability and the skills necessary to work through a complicated jury form. And I think you can effectively do that both in a summation, a rebuttal summation, and the judge in Bank Atlantic I thought was particularly good in showing the jury directly what was involved in filling out the jury verdict form.
Now, factually in legally complex cases like securities fraud class actions, there's really a premium on the effective graphic presentation of evidence. Mark and Jim, do you have any suggestions for practitioners based on your own experience?
I think the most important thing about the use of graphics and demonstratives is, again, to keep those things simple. A graphic or a demonstrative that is just loaded up with information is useless. A jury is going to look at it, the thing is going to go up on the screen, and the jury is going to stare at it and not even know where to begin. On the other hand, if you have a very simple graphic, a very simple pie chart, or a very simple line graph, or a picture that explains the business of the corporation, I think those are very valuable tools, and I think one ought to strive, my best advice there is to strive to keep those things extremely simple.
Tim? Well, the new, I say new within the last 10 years, maybe longer, reality in the trial of a commercial case, any kind of commercial case that involves documentation, memos, and now, of course, emails, is the electronic publication to the jury and typically to the witnesses of documents as they're received in evidence, as they're discussed, and so forth. And what I mean by electronic publication is that all the parties in these kinds of cases will have a trial consultant who will operate the computer and bring up at your command Exhibit 475, page 2, and highlight it on the fly, blow out and blow up key sections, and so forth. Now, no matter how complicated the case, at the end of the day, probably in closing, each side will republish to the jury 30, maybe 40 at the most of those documents, each of which would probably have been published 2 or 3 times during the course of the trial with different witnesses. So knowing what that key core of documents is and how they're going to be treated and presented to the jury is a very important part of what I will loosely call the graphics part of a trial, although it doesn't include artistic graphics. I would agree with Mark on the artistic graphics. They have to be tailored to a case, but I would just be sort of general principles are, as you're publishing those documents on the screen, you might consider having 2 or 3 key constant frame of references on the biggest blow-up that your courtroom can accommodate on an easel in front of the jury all the time, so that as they're looking at the actual evidentiary document on the screen, they understand exactly how it relates in terms of relevance, in terms of timing, in terms of the time of day, and so forth, to some of the key storylines in your case.
And Mark, from a plaintiff's perspective, are there any particular opportunities associated with the use of depositions in particular?
Well, there are times that a plaintiff is going to be required to prove much of its case through the use of depositions, and what that means is that when you are formulating your deposition strategy and actually taking the depositions, it is very important to imagine the questions that you're asking being played on videotape to a jury 2 years later. Hard exercise, but I think a very important exercise. Second is selecting out from the lengthy depositions those questions and answers that you actually want to use at the trial. In the Bank Atlantic case, for example, one of the most effective things we did with the depositions was with respect to one of the named individual defendants, rather than call that defendant as one of our witnesses on our case, we played sections of his deposition which illustrated a lack, in our view, a lack of credibility, so that by the time the jury actually met him live when he was called by the defense as a witness, the jury already had a view that this particular witness had a credibility issue. So those are a couple of the things that we use depositions for to our advantage.
Jim, anything to add?
Well, I would agree with Mark, the importance of depositions in these types of cases, because of you will have, typically you're going to have witnesses who are spread around the country or the world, very few of whom oftentimes are subject to the subpoena power of either party. So if their evidence is going to come in at trial, it will come in through deposition. The recently tried Vivendi case here in New York, I was reading the court's order on post-trial motions last night, and in the plaintiff's case, 24 witnesses were presented, 20 of them by videotape deposition. So one thing that counsels from a defense point of view during the discovery phase of the case is, even if you have not noticed the deposition of a witness, do you need to conduct an exam right then and there. This may be your last chance to examine the witness. If there's anything you want to clarify or correct in the testimony that was taken by the plaintiff's lawyer, you should have at least thought through very carefully whether you want to do that at that deposition. And you should have probably have gone beyond that and thought, do I want to do my trial examination of the witness right now? If this is a witness who is not going to be available to us at trial, do I want a trial examination of this witness now? If you don't do that, and you don't do that at any point during the case, what you're going to have is a discovery record that consists of nothing more than your opponent cross-examining witnesses on videotape depositions, and you will not have a lot of useful stuff to play at trial.
Most securities fraud class actions involve multiple sets of defendants, and as Jim points out, they're often scattered all over the country. These defendants don't always have similar interests, though. Mark, what problems and opportunities does the existence of multiple defendants, perhaps with different representation, present for plaintiffs?
Well, first of all, where you have multiple defendants that are in fact represented by the same lawyer at trial, that presents difficulties and opportunities. So one of the difficulties is that you have a hard time kind of breaking through to get information that you need to build your case. If all the witnesses and all of the defendants are represented by the same firm, you have a very hard time in getting the information because the defendants actually control the information. On the other hand, in that scenario, if you can do this at the trial, it looks like there's one large multi-person conspiracy that is part of the same fraud. So it kind of goes in hand with what your case is all about, that this was a single conspiracy where all the people got together and committed a big fraud. Where you have defendants who are separately represented, the difficulty there is that you have numerous lawyers shooting at your case. You have multiple openings and multiple summations against your case. But the benefit would be, especially where you have defendants who are shooting at each other, that's a wonderful thing for a plaintiff.
And Jim, leaving aside the distinct legal issue of conflict, any views on challenges presented by multiple or the same representation of defendants?
Well, with respect to multiple defendants, a typical scenario is what we encountered in JDS Uniphase, where the JDSU, the issuer, the company, was a defendant along with 4 former officers, very senior officers of the company, 2 CEOs, CFO, and a COO. In that case, our firm represented the company and 3 of the former officers and directors. As I said, there were 2 CEOs. There was a change in the CEO's office midway through the class period, and we represented the successor CEO. The CEO during the earliest part of the class period was separately represented for the simple reason that because he had left the company earlier, he was in a different position to make arguments about, A, I wasn't involved in any of these statements in the latter part of the class period, B, I didn't have the knowledge that you're saying tainted some of the, or you're trying to attribute to the defendants who were there throughout the class period, and so forth. It's just an example of what I think from a trial lawyer perspective, as you say, putting aside the legal issue of conflicts, it always behooves the defendant, typically at the outset, just from a practical cost-saving measure, to have as broad a representation as possible. But you always have to temper that from the first time the case comes in the door with asking yourself the question, and this often may be answered for you simply by, there may be separate representations because of SEC or criminal investigations and so forth, but even absent those circumstances, you need to ask yourself, can I effectively argue in a closing argument on behalf of all of these people simultaneously without any of them suffering, because I won't be able to advance an argument that distinguishes them from the other defendants and arguably suggests the other defendants might be more culpable than they are. You've got to make those kinds of calls early on. If I can just comment, one thing Mark talked about, defense representation of, I think he was talking about employees of a company. or former employees. This was an issue that came up in JDSU, and I wanted this as a practice pointer. From the defense side, you typically, for no nefarious reason, you typically will be involved in interviewing and representing at deposition former corporate employees. In the JDSU trial, we secured an instruction from Judge Wilkin based upon, among other things, California Labor Code provision, which basically told the jury that's entirely appropriate. Indeed, under California law, it was even the employer's obligation to provide a defense to those employees. So while our instruction was based upon California law, I would think that in other jurisdictions there might be an effort to secure such an instruction from a judge.
Our last topic this afternoon relates to the use of experts. If you're trying a simple breach of contract case, say, there may be little need for an expert to interpret the evidence for a jury, but in complex cases like securities fraud class actions, however, especially cases involving the use of statistical and scientific evidence, it may be virtually impossible for a plaintiff to meet its burden without relying on an expert. This presents the kind of paradox that Professor Gross identifies in the materials that we supplied for today's webinar, and that is, in these cases, jurors are being asked to evaluate experts whose testimony is beyond the ordinary understanding of lay people. Mark and Jim, how do you help jurors with that task?
So I think that with respect to expert testimony at trial, again, like many of the things I've spoken about this afternoon, the goal in the testimony is to keep it simple. A lot of these topics are highly complicated. A lot of the mechanics with which the expert arrived at opinions would be highly complicated. And if an expert can keep the testimony simple, whether it's through the use of graphics or through the use of simple demonstratives, that is something that is key. For example, in the Bank Atlantic case with our damages expert, the entire direct testimony was keyed off of a series of demonstrative slides, so that the jury was actually given a picture to look at while the expert was testifying about, highly complicated issues of loss causation and damages. I think another important factor is that when you actually are picking your expert, that you want to pick an expert who is a good communicator. If you have an expert who's a brilliant, mathematician or college professor, but has spent his life facing a classroom with his back and writing on the board with chalk, that's not going to be somebody that is going to effectively communicate with a jury who's sitting in the box trying to understand what it is he's saying. So if the expert can get up off of the witness stand and walk over to a chart and become a good teacher facing the jury and explain a concept as a teacher would, I think that goes a long way towards having the expert become personable to the jury and explain complicated material in an understandable way.
Jim, anything to add on that point?
I just think reinforcement, because in the securities class action, the subject matter is going to be complex. It's going to involve arcane accounting rules, statistical issues relating to damage models, and so forth. And the lawyers who work on these cases are accomplished people. I'll leave myself out of that equation. But Mark put from a trial perspective, what you want is an expert with the right DNA, which means the witness gene, which means they're likable. Not only can they get up to the podium and teach, but a jury's actually going to like them. And I don't care how good or intelligent or brilliant or qualified your expert is in the area, if a jury doesn't like him or her, odds are they're not going to advance your cause. So at the top of every rating sheet you have on a candidate to be an expert witness, I would put a high premium on likability and some proven track record that the jury's like him. Now, all things being equal, an expert who's had some experience dealing with juries is likely to be a little bit more relaxed up there and come across more likably.
And Jim, any particular views on dangers associated with expert testimony?
The dangers associated with expert testimony are are great, I think. And no matter how likable your expert, a jury is going to realize that the sponsoring party is going to hear and understand the sponsoring party is paying them to testify, and has paid them typically a lot of money in these cases, hundreds of thousands, maybe even $1 million. So there's going to be a natural cross-examination that's going to start on subjects of bias and things like that. So my point is that while the experts can help you, you got to be very sure that they don't undermine your case, because if an expert falls apart on you on cross-examination, in my opinion, it always feels like a terrible blow, a worse blow than if a fact witness falls apart, and in some ways it is, because it's a self-inflicted wound. So how do you prepare and prevent them so they don't fall apart? First, on the substance, make sure they fully understand the case, make sure they understand all the details of the case, not just within the narrow scope of their opinion, but the broader case and what's being tried there. I would make sure they don't engage in unnecessary advocacy. Explain to them, you're the advocate, they're the expert. The more they get into unnecessary advocacy, the more vulnerable they will render themselves. And when I say unnecessary advocacy, I mean not just from the stand and in their deposition, but in the reports, which the lawyers will work with them in preparing. Be careful not to load it up with things which are unnecessarily advocative, to put the witness an inch farther out on a limb than he or she needs to be. That's as to the merits. The other area in which an expert can hurt you and can fall apart even before the jury hears his opinions are impeachment on what I would call the collateral stuff. They've said, the collateral stuff consists just of the bias stuff. It can consist of they're just not qualified in this area. It can consist of opinions they've given in other cases which are inconsistent with the opinion they're giving here. And that's an area where the lawyers have to just do the due diligence and be mindful of that.
And do either of you have any comment on the effect of recent rule changes in the federal rules with respect to communications with experts?
Well, I think the new rule you're talking about is under Rule 26, where it is now definitively stated by rule that the communications between attorney and testifying expert are deemed to be work product, so that drafts, for example, of expert reports are no longer discoverable. Communications between lawyer and testifying expert are no longer discoverable. And I think it just makes the life of the lawyer and the expert a lot easier in getting a report completed and submitted, and not worry about having cumbersome communication difficulties where you're concerned about everything you say to the expert being discovered.
Agreed.
And the final question for our panel this afternoon. In cases stemming from the financial crisis, I think there's a temptation for both plaintiffs and defendants to urge that a jury send a message with the verdict. Mark, do you see any dangers with this approach?
I think that the danger there lies more for a defendant than a plaintiff, because if the defendant urges that in a summation, you have the last word, so that if the defendant is urging a message, when you stand up as a plaintiff on your rebuttal summation, you could tell the jury what the real message they should be sending is. And in fact, that happened in the Bank Atlantic case, and I thought that was pretty effective use of my 15 minutes of rebuttal.
Tim, anything to add?
Well, I think the phrase "send a message" it's kind of code for judge these people and shape your verdict not just on what you've heard in this case, but what you know is going out there generally in corporate America, be it in the financial sector or some other sector. And I think whenever you are defending a securities class action, there's very often going to be that type of argument. And in the JDSU case, it wasn't a financial crisis, but this was a case that was in the aftermath of the tech meltdown, particularly the communications meltdown in the late 90s, early 2000 period. And our defense on that case was premised on the notion that A, the facts mattered, and B, what had happened in that industry was unforeseeable to these defendants. And I think at the end of the day, the jury focused on that fact and judged those defendants on the facts of that case, on what they knew on their credibility, on their reputations, on their life stories, as opposed to getting caught up in sort of a general anti-corporate view of the world based upon that meltdown or apropos of today's discussion of financial meltdown. That's always the challenge that the defendant faces. Separate your case from something quote-unquote bad out there that the public might think has happened.
I'd like to thank both our web audience and our fine panel, and that will conclude our presentation for today.